Welcome to my overview of the approval pathways under the New South Wales Environmental Planning and Assessment Act. Environmental planning instruments, consisting of local environmental plans and state environmental planning policies, regulate the permissibility of development and the approval pathway which they fall under. LEPs and SEPs also contain categories of development known as exempt or complying development. If your development meets the performance criteria for exempt or complying development, then you do not have to go through the approval pathway nor be subjected to the mandatory environmental impact assessment process. So what are the approval pathways? There is Part 4 and Part 5. An important note to make is that environmental planning instruments do not specifically say that your development would be Part 4 or Part 5. Rather, it distinguishes the different types of development through specific type of terminology. For example, you'll see terms such as state significant development, development permissible with consent, development permissible without consent, and state significant infrastructure. Let's take a look at the Part 4 approval pathway. There are two streams under Part 4, comprising state significant development or local development. Both assessment processes are subjected to Section 4.15 of the Act, which is a merit-based approval. What that means is a decision maker will weigh up the social, economic, and environmental impacts when determining whether to grant an approval or not. Under local development streams, proponents are required to prepare a statement of environmental effects, or in the case of designated development, an environmental impact statement. Sitting under the local development stream is also a category of development known as integrated development. If your development requires subsequent environmental approval, for example, an Aboriginal Heritage Impact Permit under the National Parks and Wildlife Act, or an Environment Protection Licence under the Protection of the Environment Operations Act, your development will trigger the integrated development process. In this circumstance, prior to a consent authority granting you your development approval, they first must obtain the general terms of agreement from that secondary regulator. The consent authority for local development will either be the local council or joint regional planning panel. Who actually determines your development will depend upon the value and who the proponent is. The second stream under Part 4 is known as Division 4.7 State Significant Development. Proponents are required to prepare an environmental impact statement, and the Independent Planning Commission under delegated authority from the Planning Minister is the consent authority. State development takes integrated development under the local development stream one step further, in that it actually excludes some legislation from applying. For example, under state significant development, you do not have to obtain an Aboriginal Heritage Impact Permit. Another interesting part is that where approvals have not been excluded, it has to be issued consistently. For example, if your development also requires an Environment Protection Licence, then the New South Wales EPA must issue that licence consistent with your development approval. Also sitting under the state significant development stream is a gateway process for special types of development. For example, if your development is mining or coal seam gas on strategic agricultural land, you first must obtain a gateway certificate prior to being able to lodge your development application. The purpose of this is that it's a first overview or vetting process to make sure that your development is compatible with those agricultural land uses and values. For Part 4 developments, be it under the local development stream or state significant development stream, and you wish to modify your development application, then it must meet the substantially same test or be of minimal environmental impact in accordance with Section 4.55 of the Act. In addition to environmental planning instruments guiding developments and their subsequent approval pathway, the Independent Planning Commission can also advise the Minister about a particular type of development that should be assessed under the state significant development pathway. This is a bit of a safety net catch-all provision in the event that a new random type of major development is proposed that has not been previously considered under an environmental planning instrument. Let's take a look at Part 5. Part 5 is development permissible without consent, and Part 5 differs significantly to Part 4. Part 4, as I explained a moment ago, is a merit-based decision, whereby a decision maker will weigh up the social, economic, and environmental impacts when making a decision about an activity. Under Part 5 that does not apply. Rather, it is a test of significance requiring a determining authority to weigh up the environmental factors to determine if you're going to have a significant impact upon the environment or not. depending what the answer is to that question will depend upon what approval pathway comes next. So how do you assess that? Under Part 5, the assessment process is undertaken in accordance with Division 5.1 of the Act and Clause 228 of the Regulations. Clause 228 specifies the environmental factors that must be considered and is documented through an assessment known as a review of environmental factors. Unlike statement of environmental effects or environmental impact statement, which is specifically defined under the Act and Regulations, you will not see the term review of environmental factors under the Act. Rather, it is derived from the Clause 228 factors, hence review of environmental factors. A determining authority will review the REF and determine if a significant impact is likely or not. If it is not likely that impacts will be significant, then works can be approved and undertaken without any further consideration. If, however, significant impact is likely and the determining authority is the proponent but is not a council, that means the activity must now be assessed under the State Significant Infrastructure Pathway, which I will explain further in a moment. If a determining authority determines that a significant impact will result and the proponent is not the determining authority or is a council, then they must prepare and consider an environmental impact statement under Division 5.1. This is not the State Significant Infrastructure Pathway under Division 5.2. Part 5 is normally related to infrastructure type development such as power lines, water supply systems, schools, correctional centres, rail, etc. In circumstances where the proponent would not be the determining authority under Part 5 would be for matters such as mineral exploration or petroleum exploration. Let's take a look at the second stream under Part 5 being State Significant Infrastructure. A proponent is required to prepare an environmental impact statement in the Independent Planning Commission as the consent authority. Similar to State Significant Development, it excludes some legislation from applying. Again, similar to State Significant Development, where those approvals are not excluded, they must be applied consistently. Where State Significant Infrastructure differs from State Significant Development is that modifications do not need to meet the substantially same nor the minimal environmental impact test. There's a lot more flexibility for developments assessed under the State Significant Infrastructure process. Similar to State Significant Development, the Independent Planning Commission or Infrastructure New South Wales may make recommendations to the Minister for particular types of development to fall under the State Significant Infrastructure process. Again, it's a catch-all provision, similar to the one that we saw in the State Significant Development stream. So there you have it. There's my overview of the approval pathways under the New South Wales Environmental Planning and Assessment Act. The rest of the presentation is just based upon summarising those approval pathways that we just reviewed. So there's Part 4 of the Local Development Stream and Integrated Development, and also State Significant Development, not to forget about the Gateway Certificate for particular types of development. Part 5, which is a test of significance and differs to the Part 4 merit-based approval decision. And lastly, we have the second stream under Part 5, which is State Significant Infrastructure. There you have it. That's my summary of the approval pathways under the New South Wales Environmental and Planning and Assessment Act.